What happens when two seasoned business leaders get together? They talk shop, of course. Sit back and listen in as Scott DeLong and Vince Moiso share from their experience around current issues facing executives, entrepreneurs, and their leadership teams. The CEO Podcast starts now.
Hey everybody, Vince Moiso here with the CEO Podcast. And as always, I'm here with Scott DeLong.
Hey everybody.
And we've got a special guest back for a second time. Yeah, guess who's back? Andrea's back. Okay, so we've got Andrea Paris with Andrea Paris Law. And if you remember in our first episode, she really schooled everybody, schooled us and certainly our listeners on everything you would want to know, especially as it pertains to California employment law. And it was great. I think we covered so much in a short amount of time. And there have been updates since that time. And so we thought it very appropriate to have a second episode and bring Andrea back and give us a few updates. And then I think even, Scott and I have a few questions around what some of those updates mean for California businesses, right? And then Scott made a point earlier where, what that impact is when things happen in California, they tend to have influence over what happens in other states as well. So Andrea, thanks for joining us again. Appreciate you taking the time to get our listeners updated and get us updated. Anything that you want to talk about, quickly with your background? Again, I think it's appropriate just to spend another, we have new listeners and we have other people that are listening that may not have caught that previous episode. So I think it'd be really great if you just spent a little bit of time with your background and maybe if you caught people up on just a couple of points of not necessarily that's new, but that's important to pay attention to.
Sure. Thank you for having me back on. I had a wonderful time the last time we had a conversation, and I'm really excited to be here again. My name is Andrea.
We did too.
Great. Thank you.
Yeah.
The feeling is mutual. My name is Andrea Paris, and I am the founder of Andrea Paris Law. And we are in Orange County, California, but we represent clients all over the state of California. I do employment law, exclusively employment law, and we advise businesses keep them out of trouble so that you don't get sued. My thing is always educate. I love carrying my clients through and advising them through decision-making processes. And what I love about employment law is that the law is always changing. So I'm always learning new things. It is difficult for companies because the laws are always changing, but guiding companies through not just the legal aspect of it, but also the human aspect of it, the psychological part that comes with employment issues is what I really enjoy. And because I litigate for a really long time, I see what things get disputed. And because I get calls all the time from both employers and employees, I can see, what triggers an employee. I can see what prompts them to call an employment lawyer. So getting to guide clients through that is a really fun part for me.
Can I stop for just a minute? Because you said something that I found really important, and that's guiding people before they're getting sued, right? So I've been in business all my life, and usually when I call an attorney, it's after I have a problem. So talk a little bit about the pre-work that you do with your customers. And I think the benefits are obvious, but you can talk a little bit about the benefits that you provide to that as well.
Yeah, sure. I have clients who are on, what we call a support system. And I always ask my clients to call me before you do anything. And the trigger areas, I think, where there's the biggest areas of exposure are whenever you're hiring people, whenever you are going to discipline someone, and before termination. So those are really the areas where, you go, hey, let me just pick up the phone and call a lawyer real quick, because that quick call can really help you stay out of trouble and save you a lot of money. And because in California with employment issues, if you are found to owe an employee, $1, $2, $10, you have to pay their lawyer's fees. And so a small problem can become a really expensive problem. So I ask my clients to just pick up the phone, call me. And then also a big part of it is having an employee handbook and having a good handbook, because that will be your guidance and that will help you deal with, I'd say, 80% of the issues that will come up in the workplace.
I like that point. In fact, I've always not enjoyed, but insisted on having employee handbooks. But I've heard an opposite point of view as well. And I've heard business owners say, don't have an employee handbook because then you are bound to what's written in there as well. Now, you're bound by California law anyway, right? So I disregard that, but I have heard that comment before from folks. No, you don't want to do that because now it's too restrictive, right? What are your thoughts on that?
So my thoughts on it is, like you said, you are bound by California laws anyway. Yeah. The employee handbook and just the process of creating the handbook helps educate, especially small business owners who are doing your own, you're coming up with your own rules. You're the one who's providing sick leave. You're the one who's dealing with employee issues. If you don't know what the rules are, you are not going to follow them correctly. And it's, a lot of it's very technical. And just the process of creating that handbook will educate the business owner as to what those rules are. And so that's one part of it, right? And the other part is it's a management tool. On the parts that are not related to the law, you have the ability to make it as restrictive or as non-restrictive as you want. And where I see small business owners run into trouble is they take handbooks that were created from their former employer, who's a bigger company and is bound by different laws, and then just, takes that and goes, okay, this is going to be my handbook, but, I only have 3 employees or 5 employees, not 100 employees. So now you're binding yourself voluntarily to the laws that apply to a 100 company employee company. So that's where I think the difference is. But it's a management tool. And I tell my clients this, that it almost creates a third-party bad guy, especially if you are the one who's doing HR within your company. You can go, hey, you know what? Yeah, so sorry. You violated policy, but it's in the handbook. It has nothing to do with me. I'm not the one who is being the bad guy here. It's, it's our policy. We kind of just have to enforce the policy, and you get to determine what the rules of engagement are in your workplace. So how I look at the handbook as, twofold.
I learned something.
Go ahead.
I learned something. I was going to say, because I learned something new about you, Scott, that you enjoy employee handbooks.
Yeah,
so that's interesting. I did not know that about you.
Rather than enjoy. So
yeah,
sorry.
Sure. No, it came. Usually the truth comes, rolling off the tongue perfectly. So I hear you, bro. Hey, listen, I'll go.
I have no life, Vince.
I'm going to get you a copy of mine. I want you to take a look at it because I want that for you. Just enjoy it. One thing I want to say is I really want to encourage our listeners. We actually dove pretty deep into that, if you guys remember, into that in our first episode together. And I would encourage our listeners, go back and really take a listen to that, because we really did talk about the resources that are available around developing an employee handbook and the importance of having an employee handbook. Scott and I sit on the same side of that. You should have one. So I don't agree that, with those that say, I don't want to have one because it's too much liability. It's, to me, it's the opposite. And I think the 3 of us agreed upon that in that first episode. And Andrea, I picked up on something that you said that I didn't last time. And we didn't really talk much about this. And you mentioned the human aspect of your relationships with your clients. And I started to think about, the number of, let's say, not lawsuits, but legal situations within business over the years that I've been in business, and how often, like, I've come a long way and have just really stripped the emotion out of it and been able to look at it from a different lens. But it's so emotional. And you used the word triggers, right? And And so those are triggers where people can get a hold of you early on. And it does reduce the amount of motion, but on both sides, there's just a tremendous amount of motion. So I would imagine whether you're representing the employee or the employer, there's a lot of emotion around there. Can you just talk for a minute or two on how you deal with that? Because I feel like you have to be part therapist sometimes, I'm sure.
Yes. You know, other attorneys, I have a lot of other attorney friends, and we talk about that all the time, how we feel like part of our job is almost acting like a therapist. So yes, with my companies, listening to, where the employer is coming from and letting them know that I do understand that either, this feels unfair, or, the employee really has just not done a great job. They are taking advantage of the system. Those are the emotions that come up a lot. And so understanding, and I get it. I know how difficult it is to, run a business and to have employees. So listening to the clients and understanding the emotions and what they are going through, but also allowing the company to see the other perspective as to how things might look to the employee. And the number one thing that I always say is make sure it doesn't come as a surprise. If you're going to terminate the employee, sure, it's a pain to have to document things, but really not letting it come as a surprise is going to be a huge thing, because that's the one thing that I get on the employee side all the time is, hey, I didn't even get a warning. Granted, there's no requirement that there's a warning, but for some reason, people have that feeling that, hey, you can't just fire me. You didn't even let me know what I did wrong. You didn't give me an opportunity to fix it or correct it.
Right.
And so that comes up a lot, is that, hey, I never even got a warning, is the thing that I get on calls all the time. And the other thing is surprising, and I guide my clients through how to terminate an employee as well. And the one thing is that comes up on the employee side a lot is not being treated with respect, or them feeling like the termination was disrespectful. So when people just get ushered out of the office in front of everybody, or somebody standing right over them as they're packing, that just drives people nuts. It really, really makes them mad. And when people are upset, that's when they call a lawyer.
Well, those are leadership philosophies as well, right? For instance, the first one, not let it become a surprise. I mean, that's part of our responsibilities of coaching our employees and working with them.
Right.
And what I found to be the case is that in most instances, when I have put the time in to doing that coaching with somebody, either they get better or it's time to leave, and they self-select to leave rather than wait to be fired anyway. They recognize that it's not the good fit for them either. And that's an opportunity that you can have to save all of these legal issues, certainly, right? So I mean, I wouldn't think law and leadership fit together, but you just made a case exactly how people should be acting, how we should be acting as leaders.
It really does. And I find that, being a part of the EO community, or even just reading leadership books, or, taking courses on, how to lead people and just human psychology, has helped in my ability to guide clients through tremendously.
Yeah.
And even, providing resources to clients is really important.
That's great. Hey, let's talk a little bit about the changes that are happening. I mean, this episode is going to air right at the beginning of the year. So good time for people to be self-aware. And there are some significant changes that are happening, at least in California. And again, as Vince mentioned, what happens in California tends to set a pace for the rest of the country coming up. New York usually jumps right in. Some of the other states start coming in slowly. So it is significant that we talk about the employment law in California. So what are some of the major changes coming up beginning of the year?
First big change is in sick leave. So in California right now, the rule is that you have to give 1 hour for 1 hour of paid sick leave for every 30 hours that somebody works. And then there are alternative methods of providing sick leave. You can front load 3 days of sick leave, or you can also, alternatively, if you have a paid time off, PTO policy that provides for the same amount of sick leave as the paid sick leave laws, then that can apply. And as long as the employees can use the leave for the same reasons that they are allowed to under the paid sick leave laws, then that's okay. So the big change in California is that it went from, if you were using an alternative method of providing paid sick leave, so anything other than 1 hour for every 30 hours worked, that minimum requirement is now 5 days instead of 3 days. So that is the big thing. If you are front loading paid sick leave, make sure that anywhere that you are giving 3 days, that you are now providing 5 days of leave. And then there are also changes in where you can cap use. So employers have the option of capping how many hours or how many days of paid sick leave an employee can use within the year. So you can accrue more, but an employer has the ability to cap use within the year. So that minimum on the cap has increased from 3 days to 5 days. So again, anywhere where you initially were giving 3 days is now 5 days. And then also the accrual threshold. So that has now doubled. Employers used to be able to cap the accrual of paid sick leave at 40 hours. Now that cap has increased to 80 hours for accrual. And then carryover. So you have to allow employees to carry over at least 5 days or 40 hours of paid sick leave into the next year. But you can still cap it. So let's say an employee may have carried over 40 hours into the next year, and in the next year, they somehow accrue another 40 hours. You can still cap use at just 40 hours rather than allowing the employee to use 80 hours that they have accrued.
And so it doesn't matter if it's PTO or sick days. The sick day policy is the one that's guiding how many days. That's like, doesn't matter what you label it in your employee handbook.
So they run parallel. You do not have to provide additional sick leave, paid sick leave, if your PTO policy provides for, and this is a change as well, is that your PTO policy allows them to have allows them to have at least 40 hours or 5 days of paid sick leave within the first 200 days of work.
Okay.
So but if your PTO policy doesn't give them that much sick leave, then you have to provide additional sick leave.
Did the language change because it seems like there's part-time employees as well. It used to be 1 hour for every 30 hours. Now they're just talking about days. So has the language changed?
No. So it's always been, the default is 1 hour for every 30 hours of work, unless there are alternative methods. Okay. So you can choose, and I ask my clients, okay, do you want to give the 1 hour for every 30 hours of work, or do you want to front load? Because if you front load, the front loading is the alternative to that accrual method of 1 hour for every 30 hours of work. Okay. The thing about front loading is that you don't have to allow for carryover. But if you don't front load and you're doing the 1 hour for every 30 hours of work, you have to allow for carryover into the next year. So that's the difference.
All right.
Well, and I do know that there are a lot of companies that, even though California was only 3 days, they were already putting 5, some do 7 days, there's you can always do more. That's the minimum. So I think that was the key word that I was hearing you say, is that's the minimum. So for those that are listening that are already at 5 days, they're good. Like, they wouldn't necessarily have to change their handbook as a result of this law change. Is that accurate?
Yes, that's correct. The minimum threshold has changed, but if you were already providing more than the minimum threshold, and some who may have been providing more than the minimum would have been people who were subject to ordinances in cities who provided for higher paid sick leave thresholds like Los Angeles or San Diego. But this new law says that these rules now preempt the local ordinances, which makes it a lot easier for us who draft handbooks, because then now, and then also for companies to administer, because you used to have to figure out, okay, well, if somebody's working in LA, their threshold is higher, so I have to give sick leave. But now it's just the minimum threshold applies throughout all of California, and you don't have to worry about the local ordinances, which makes it easier.
Interesting. Okay.
So we've used the word minimum a lot. So now let's go to the hot button issue, the minimum wage changes.
Okay.
Talk to us about, and they're industry specific now. I don't know if that's normal, but California has a high minimum wage and it's going higher.
So the minimum wage right now in California is, wait, let's see. Sorry, I had I
think it's $15.50 this year.
So next year it will be $16 an hour, which means that the exempt employee threshold increases as well.
That's right.
For exempt employees, they must be paid a salary of at least $66,560.
Wow.
But there are still local minimum wage requirements. For example, so still you have to check your city's minimum wage requirements. The city of San Diego's minimum wage next year is going to be $16.85 an hour. And Pasadena, which goes into effect in July of next year, is $16.93 an hour. So as for industry specific, I don't have the details.
I've got a couple I'll talk about because I found this fascinating. The fast food worker minimum wage up to $20 an hour.
Yeah. Yes.
Burgers are just about to get more expensive.
Which
Sorry,
means,
Scott.
in fact,
I know you love McDonald's, buddy, but maybe you can't afford it anymore.
The dollar menu is no longer going to be the dollar menu, I don't think.
Well, what they do is they shrink the burger, so it just keeps getting smaller, I think.
It's probably better for me anyway.
Yeah. But here's the thing is you wonder if this will then push more companies to automate and hire less people in the fast food service.
Yeah, and you can see that happening right now. I mean, if you walked into a McDonald's right now, they are almost forcing you to go to the kiosk and order from the kiosk. So while minimum wage goes up, and obviously the bad side of that is that less people are going to have jobs. It's just it does two things. One, it gives the hamburger company an opportunity to raise the cost of the meal, blaming the big bad government for their cost increase, while they're automating and getting rid of workers at the same time. So I actually see profit margins going up in the fast food industry because of the combination of those two things.
I can see that, and also because that has the ripple effect of decreasing the costs of workers' comp insurance, for example, and other, the costs that come with having employees.
No question. Well, it also prevents, it's Scott and I had a brief conversation earlier about this, and he brought up a really good point. It's not often, Andrea, but sometimes he does bring up really good points.
Or you giving me credit for a really good point would be rare as well.
I give you all the credit for this, but because it was really astute, where you've got on the employer side, when you think about it, and I think about it because in my business, what that's going to do is prevent me from hiring other positions. And so I'm ultimately going to have to put a little bit more pressure and expand responsibility with the people that I have. And it's going to prevent me from hiring where I might have hired, in a less expensive environment. So as an employer, it's a struggle because my costs go up. I may have to raise prices as a result of that, whatever it might be, depending on the industry that you're in. But, Scott brought up the point too, on the side of the employee, when you're living in California, it's hard to live in California right now. It's really expensive. And so there is that side that California does have to raise these wages because they have to have a living wage. People need to be able, if they're going to be in California, they need to be able to afford the gas prices, the food prices, the stuff that you need to live on a daily basis. And
Right.
so I think it's a real conundrum of where we live in a world. And I even hate I'm fascinated by automation. We're as a business, we're going through that right now as well. So there's a lot of things that we're changing and moving toward automation because we have to, for the reasons that you mentioned. At the same time, that gets rid of jobs. And so we've got this conundrum that just continues to happen in California. And I don't know that there's a real solution for it.
That is very true. And I mean, the cost of housing, young people have a really hard time. And I see a lot of, even in my life, a lot of people leaving California, not just business owners leaving California, but people who just can't afford to live here and with remote work are moving out of state and living in cheaper states. And then that then raises the cost of living in those states as well.
It sure does.
There definitely is a effect there. Vince, you said something that made me think of what I do get calls on quite a bit, or comes up in conversations, is that when you say that employers then have to kind of put more duties on fewer employees and expand those duties, I see on the employee side where it affects. People think that, you know what, they hired me for this position, and then I'm now doing the work of, 2 people, and they're not hiring and they're not giving me support. And then that, even though not illegal, employees feel like they are not being properly compensated or
treated fairly.
Right. Or that they are, that somehow this now creates a hostile work environment. So in the legal definition of hostile work environment, that wouldn't normally fit, but it creates that story in the employee's mind. So this is where I think it's really important when you hire people to provide a job description and also let them know that, hey, the job description, this can change, and it will have to change with the company's needs and what happens within the company. And when it does change, have that conversation with the employee and update the job description, because I think that communication is really important with the employee.
We actually incorporated language like that into the job description itself, because just having the conversation isn't enough, because people forget having conversations. Or say that was never said to me, or whatever's going to happen. So we put some language at the very bottom and said, here's the job description, and which can change from time to time or based on the needs of the organization, blah, 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 right?
Yes.
Well, I think the mistake that gets made, Andrea, to your point, it's a great point. And we do all of that. I totally agree. Make sure your job description, has that clause in there for expanded responsibility, but that's not enough either. And the conversation's not enough. So I think of it this way, so you said, the equivalent of that minimum wage change to salary, an exempt employee, is $66,500, I think is what you said, roughly. So here's what that boils down to is that, okay, well, I've got to raise, so I'm already looking at that. I was thinking about the few employees that I'm going to have to raise up on that minimum, which is fine. And frankly, they deserve it. So great, no problem there. But I have to consider that in our overall budget for the year. And then if I was thinking about hiring somebody, now I'm rethinking that, which in this case I am. But the next step that you take, so with the existing employees, I'm saying, hey, I'm going to put a little bit more responsibility on you. And that's going to come with a title change. And actually, I'm going to bump your salary up just a little bit to compensate you appropriately for the expanded role. So if you think about it in that way, which I'm always thinking about it, so I'm spending $10,000 to increase that person's compensation, their salary, versus spending $66,500 to hire somebody new in that role. They're really happy. They got a raise. it was clearly articulated and explained what that expanded role and responsibility is. I think what happens more often than not is most, especially in the small business space, most small business owners just say, I need you to do more. And that's the end of it. And there's no discussion around compensation, expanded role and responsibility. There's no job description in place that explains that their role could change. None of those things are in place. But hey, the good news about that, Andrea, is that's why you have clients.
So you just touched back on the leadership principles that we always espouse as well. More communication is better than less communication.
Totally.
Making sure people understand the why behind the what is really important in order to help mitigate these hard feelings, the thought of a bad workplace, right? No matter what the law is, we're still dealing with people, and we have to treat people with respect, with dignity. And it's still a net loss for you. Your scenario, Vince, you're saying, okay, I got to bump that 10,000, but I'm not going to do the 66,000. You can't double their work output, right?
No.
Yeah, I mean, it's like you're not gaining anything. You're certainly losing again. So we have to work that into our business practices. But the whole key to all this, I'm going to go back to, and it's just communication. Just communication. Continue to communicate with people. Make sure they understand who you are, what your needs are, what you're doing with them, not just for them, but with them, and how they impact the business and what these roles and responsibilities is going to help. It's not a panacea. It's not going to be. It's going to save you from all lawsuits, but it's certainly going to get you closer to that than it would by just making changes on people's lives.
I absolutely agree.
Andrea, I know that there are a few more updates, and we probably only have about 5 or 10 more minutes here to finish up. So I think Scott and I should probably shut up and let you go through a few more updates.
Sure. The other big one, and this also has, come up a lot, but now it's been clarified in the law. There is now a new rule that any adverse employment action that is taken within 90 days of an employee engaging in a protected activity creates a rebuttable presumption that the adverse employment action was retaliatory. Okay, so I'll explain what this means. A protected activity that's subject to this 90-day kind of protective period of the employee is if the employee made a whistleblower complaint, filed a claim with the labor commissioner, wrote or made an oral complaint to the company about unpaid wages, if they initiated a PAGA action or testified in a PAGA action, if they made a complaint regarding pay inequity that's based on gender, race, or ethnicity, and if they disclosed, discussed, or inquired about their own pay or the pay of other employees. So if they're making those pay inequity questions, that's protected activity. And also just generally, if they exercised any rights afforded to them, either on their own behalf or behalf of another employee. Whenever any employee takes that type of action, they now have almost a 90-day protective action where if you demote them, you fail to promote them, you terminate the employee, and they file a claim for retaliation, there's going to be a presumption that, yes, you terminated them or engaged in the adverse employment action in retaliation for them exercising those rights. But it's rebuttable. So that means that the employer can then provide evidence that says, oh, no, it was because of performance or whatever. But it's always difficult for you to have a presumption in favor of the other side and for you to have to then, defend yourself and go, no, that wasn't the reason why. So that the rule has always been, yes, timing matters. The courts will generally look at the timing, but now we have a definite time frame. It's 90 days. So how employers can protect themselves is normally before a client terminates an employee, I will go through a checklist a bunch of questions. And one of them was, hey, did the employee recently, take leave or complain about anything? And we'll talk about that and when that happened. And so now I think that is definitely something that everybody should add to their pre-termination checklist is, hey, just take a look, because sometimes you're not consciously thinking about things, especially if you're not retaliating, but you are just by the timing of it creating that rebuttable presumption. So before terminating an employee, I would definitely check and go, hey, did this person file a PAGA claim or filed a claim with the labor commissioner or complained to us about their wages or another employee's wages or asked about how they're being paid? Any of these things, definitely, take note as to when they made those complaints and know that you should probably wait at least 90 days before taking any action.
Unless, though, there are some actions that are intolerable, like being drunk on the job, sexual harassment, stealing. I mean, that doesn't mean you can't have disciplinary action or fire somebody, but you better have evidence and documentation.
Absolutely. Yes. And I actually had a client who recently had an employee who is a driver show up to work intoxicated and was sent home and reached out to me and said, hey, what should we do? And, I said, hey, you know what, this is definitely a situation where, and it's rare because I'm pretty risk averse, but I know that this is definitely one of those situations where you are creating way more liability by not terminating the employee, than if you were terminating the employee. But also, it's true that there are things that are intolerable and you need to terminate employees, but also make sure that you're treating employees the same way.
Equally,
if there's something, if something happens and it happened with another employee and you gave them grace, you better make sure that that you're treating the employees in the same manner for offenses.
Absolutely.
Yeah.
So that is a big one for employers. Also, this new one is non-discrimination for off-the-job cannabis use.
Yeah.
You cannot, discriminate against a person in hiring, in termination, or any terms of employment because of, their use of cannabis off the job. And also, if you do pre-employment drug screening, you cannot use a screening that will look for non-psychoactive cannabis metabolites. And that's just, the stuff that's left over that shows that they've used cannabis within the last few weeks. So you will actually have to use a pre-screening drug test that will test for, the presence of THC or other things that will actually mean that, they're presently high or are affecting their ability to work at the time that they took the drug test. So that's, a big thing.
And add it to your do not ask list too. You're not going to ask if somebody's pregnant or planning on being that. And now you don't talk about their use of cannabis.
Yes.
That's huge. That's a big change.
Regarding prior use of cannabis either.
Wow.
Except, there is one exception, is that employers in the building and construction trades are not subject to this yet. But there is definitely a discussion as to whether that exception will then go away.
Wow.
Well, Andrea, why don't we just in the sake of time here, because we're getting toward the end, and I know that there's more and there's a lot more details that you can go into so many of these things. So we'll make sure that we post your contact information so that if any of our listeners want to get in touch with you for more information, they can certainly get it. And then if you want to just quickly let everybody know verbally, how to get a hold of you and how they can get more information from you.
Sure. You can always reach me at my office at 949-529-0007, or you can find me, just email me at AP, my first and last initials, at AndreaParisLaw.com. And that's ANDREA, Paris, like the city, France, law.com.
And I'm going to make a suggestion to our listeners to call her before you need her, right? Do this work in advance to make sure that we don't get into any more lawsuits. So.
No question. And if you're if you're working with an employment attorney, I mean, it is, and we do that. We do it often. We had a recent situation, and it's just the more you can get out in front of it, just the easier it ends up being. This last one, and I've been through several, but the last one was so great because we were so prepared going into that meeting, and it actually ended up being a very, very calm, very mutual scenario as a result of being incredibly prepared for the situation. So,
treating the employee with dignity. I mean, I know this case, but treating them with dignity matters.
Yeah, it matters. It absolutely matters. So I know that there are situations, like when there's alcohol involved and stealing involved, or, there might be, injury and things like that, where you just have to react and you just have to, make decisions and stuff like that. But anytime that you can certainly proact, I highly recommend it. Scott, any last words from you?
No, Andrea, I just want to thank you for being here with us again. This is an ever-changing world, especially in employment law, and we appreciate you coming back and working with us again.
Thank you so much.
I feel like here. Yeah, sorry, Andrea. I feel like we could have gone easily another 30 minutes. It's such an important conversation, and there's so many examples that we could give. And Andrea, I thank you very, very much for giving us and giving the listeners all that information is so important.
You're welcome. And I just want to add, since you mentioned we probably could have kept going on. If anybody wants, I did a presentation on the updates that are coming up. If you want a link to that video, just shoot me an email and I'll be happy to send it to you.
Love it. Thank you for that offer.
Much. All right, folks. Well, we're at time again, and we really appreciate you listening. As always, if you want to get any information to us, scottandvince@gmail.com is an easy way, or pick up the phone and call either one of us. We're easy to find. So until next time.
Yeah, until next time. Cheers.
Cheers.
Thank you for joining us for the CEO Podcast. Please visit us at theceopodcast.net, where you can learn more about our co-hosts and listen to past episodes. If you would like to have a discussion and dive deeper into any topic, there is also an option to contact Scott or Vince to schedule some time with them. Thanks for listening.